Could you give examples of how things could play out if there is no plan? How things could play out if the plan has been improperly prepared?
If it's been improperly prepared, the assets may not go in the way that you want, and your estate may still wind up in probate. For instance, I have seen people who prepare a trust, have somebody prepare a trust, and they just go get a form. And what they haven't done is that they haven't funded the trust properly. Because in order for the trust to work, you have to fund it, which means that you have to title the assets in the name of the trust. And if you don't have certain types of language in the trust, you won't even be permitted to transfer those assets after death into the trust. So you have to plan ahead and plan properly, not just throw something together, because we're talking about everything that you've earned in your life. And you want to make sure that it goes to the people that you care about in the right way.
Joint tenancy. Many people hold real estate and other assets in joint tenancy with the belief that it's a form of estate planning. This is fueled by the thought that since we acquired it together, if something happens to one of us, then the other gets it all. From an estate planning perspective, what do you have to say about that, and is that a viable plan?
I know that many married couples will use joint tenancy. Most married couples have their property in joint tenancy. But what that also means is that if it just goes by joint tenancy, that means the surviving spouse will have sole say-so as to how that asset is ultimately distributed. You will have lost your rights upon your death because the person who's alive now has that asset in total. So let's say that person remarries, and they find they love the person that they're with, and they may have new children. That asset may be lost to the deceased person's children. If that's of concern to you, you'll certainly want to plan to make sure it doesn't happen. The other problem with joint tenancy, and I hear this a lot because we do estate planning seminars every month all throughout Los Angeles and San Bernardino County. The other problem is that people will often say to me, well, listen, I just want to put my daughter's name on the property. And my answer is always the same. Don't do that. Because if you put your child's name on the property, you will incur every problem that that child may have. If that child winds up in a divorce, so is your property in that divorce. If they file for bankruptcy, so have you. If they get a tax problem, so have you. If they get sued, so have you. You don't want to put the assets in the name of someone else unless you are absolutely sure that nothing will ever happen to that person, and that can only be if that person is living in a bubble. So in addition to that, there will be a capital gains tax problem that the person will incur that they don't need to have. A big one. Could be a big one.
Living trusts. Exactly what is a living trust? And if an individual can be the trustee of his or her own living trust, what benefits or protections, if any, does the trust offer the trustee while they are alive?
Well, a living trust is, well, let me start by saying a trust is a document that is created by which you have named a person to be in charge of your assets if something should happen to you, or either with regard to your disability or upon your death. A living trust is such a document that is prepared during life as opposed to at death. If you don't have that living trust in place, you of course will find yourself again subjected to probate. When we talk about having a living trust is just one item in the estate plan. The estate plan will encompass the living trust, which is the centerpiece of an estate plan. Then there's a document called a pour-over will, which is unlike the standalone will in which you say, I hereby leave my earthly possessions to that person or that person. A pour-over will is used only in conjunction with a living trust. And it's to make sure that assets which you acquire after you've prepared the estate plan can be poured over into the trust. Then you include the powers of attorney. You will have powers of attorney for health care. You'll have powers of attorney for financial management, often referred to as the durable power of attorney. So when we talk about the living trust, that's just one item that needs to be done. There's a full plan that will make sure that you're protected.